I think they filed something out of order. Hey guys, this is Jules with True Crime Reactions. Disclaimer. Everything stated in this video is my opinion and my opinion only, and just like everything else in these cases we discuss here on this channel, everything is alleged. Okay, so I just finished recording a video, and so I checked the Idaho Case of Interest website to see if there was any new documents, because there wasn't prior to me starting my recording. Now it is 6:15 p.m. and I checked it again and there is a document, but I feel like it's out of place because it's the defendant's response to the state's motion to limit testimony. And there is not a document prior to that. The last document that was posted was the Zoom participation for Leah Larkin and Becca Barlow. So I'm not really quite sure what they're responding to, but I'm going to go ahead and record this and get this out now because it's posted, and I'm just going to assume at some point that we'll get the state's motion to limit testimony. Because remember, we do have a court date tomorrow. Now, these hearings for the 14th and the 16th are closed to the public. There will be no live stream. Hopefully we get some sort of documentation after the fact, which I'm sure that we will. But let's just go ahead and see what this document's about. Defendant's response to state's motion to limit testimony. Comes now Bryan C. Kohberger by and through his attorneys of record and hereby submits the following response to the state's motion to limit testimony filed May 10th of 2024. Okay. Yeah, that's not, we don't have that. We don't have that. So for some reason, it's not being shown to us just yet. In the state's motion, the state contends that the affidavit of probable cause is irrelevant at this stage. State's motion at 4. What does that mean, state's motion at 4? The state cites no authority for this claim. Mr. Kohberger has the ability to challenge the probable cause affidavit in this matter that were used to procure warrants. Finding informers' reliability a relevant issue as it related to probable cause for a wiretap. Holy crap. What the heck does that mean? Are they saying that somebody was wiretapped in an interview? Hold on. Okay. They are wanting to fight the probable cause affidavit. That's what it sounds like. They fought the grand jury. It didn't work. They want to fight the probable cause affidavit. Okay. They are citing a case that states State versus Thompson, and it's from 1988, so it's a long time ago. And in parentheses, it states, finding informers' reliability a relevant issue as it related to probable cause for a wiretap. So does that mean that somebody was wiretapped, like somebody's person or somebody's phone at some point when it comes to them getting warrants, and there's some stuff there that we don't know about? Okay. So then the next one is State versus Hosey, also from 1988. Finding informers' reliability a relevant issue as it related to probable cause for a search. Now we have State versus Hosey of 2000, and then State versus Pendleton from 2023, so a more recent case. And that says, finding field performance of drug dog properly discoverable as relevant to probable cause inquiry. I'm confused. The finding of an indictment does not preclude a defendant from seeking to gain through discovery information relevant to the probable cause provided to the court. Dated, okay, so this is something that is dated May 10th, which would have been Friday. So, okay, this is a little bitty document that says a lot, and I'm very confused. I am not trying to like jump the gun on what this says, but they are only going to cite laws and cases that are relevant to the very specific details of their case. They cannot cite a case for wiretaps if there's not one being used. They cannot cite a case for drug dogs if there's not a drug dog at some point in the case discovery, right? Like this is very confusing, and it's a lot confusing whenever we don't have what they're responding to. Now, I'm refreshing and I do not see anything else. So, with whatever the state ends up filing about testimony being limited, they're going to say that doing anything when it comes to fighting the probable cause affidavit is irrelevant at this stage. But what does that mean when it comes to limiting testimony? Like they just don't want anybody at all to talk about the probable cause affidavit? But the probable cause affidavit is where all of the like timings and things are that they use to like say that that's like the location and the ways that he went everywhere. And isn't that the stuff that Cy Ray is supposed to be coming out and like basically disputing? Because he can apparently like prove that it's wrong, at least according to what the defense is claiming. I am just kind of like surprised about the whole like they're talking about informers and wiretaps and informers with searches and then drug dogs and things like that, and that is just wild to me. Yeah, I'm gonna keep an eye out for whatever the state is supposed to be filing here, but it's not showing up for me. So yeah, I don't know what to think right now about that. Hopefully they get that fixed, but I don't know why in the world. Like, how much does the clerk of court actually get paid to make a mistake like this? Not filing things chronologically. Because obviously, if the defense can respond to something and they have a filing date of, then that means that it's available and it's like with the clerk of court as of a stamped filing date. So where is it? And then it says testimony instead of testimony. It's misspelled. Maybe they'll fix it. We'll see. Wild. I don't even know. That's it, you guys. I guess we'll see whenever they actually put the original document that this one is a response to, and we'll be talking about that one whenever they release it. But that is it. If you like the way that I present this information and give my opinion, please do not forget to leave a like on your way out and subscribe to the channel if you are not subscribed already. See y'all.